Hello, I'm Dan Key, and welcome to People's Law School on Channel 2 Paducah. Today we're going to be talking about real estate. I am your host, and I will be assisted by Neal Oliphant, who is a partner with Denton and Coiler law firm in Paducah. Basically, the most important and the largest investment most people make is in the purchase of a home, and Neal and I are going to be discussing some of the requirements involved in purchasing your home. The first item that one would, as you can imagine, one would require is to find your home or to contract for your home, and this is normally done either through a private sale with directly with a seller, or through a realtor or an auctioneer. And the first document that you would require would be a contract. A contract should be in writing to be enforceable, because an oral contract is not an enforceable contract. Now, Neal, can you tell some of the requirements that a contract would have for the purchase of real estate?
Well, generally, the major elements are, of course, the purchase price and how that's going to be paid for, whether it's owner financing or if you're going to get a loan for the bank. And, of course, the legal description of the property would be a major thing. And normally the contract, if you use a realtor, the standard Paducah Board of Realtor contracts calls for or allows you, the buyer, to have an inspection of the property to disclose that where there might be any defects in the property, and gives, if there are any defects, the time for the seller and buyer to come to agreement on how to correct those things, which is always, which we can get to, but we might as well say that now. If you do find some problems with your home after your inspection, then that could be a problem. So it's always good to have a home inspection, so any problems with the house itself you can find out about it before it's too late, basically. But those are mainly the essential ones: the purchase price and the legal description of the house and an inspection.
Yeah, you can. There would be some certain other optional provisions, such as if someone is living in the house at present and not the owner, and they're going to continue living there, you may want to prorate the rent between your buyer and your seller, and also set up whether the taxes are prorated. And if it's an older house, there may be lead paint in there, and you want to have a lead paint warning, because lead paint creates some problems if it gets ingested by young children. I know that some of these contracts also will call for possession dates other than at closing, which may give someone an extra 30 or 60 days to continue living in the house. And if they do, often the purchaser of the house, who does not get possession but has purchased the property, then will be allowed to receive some sort of rent for this period of time. You also want to make sure that a good faith deposit is paid, and you designate who will hold that deposit and on what conditions it is to be paid out in the event the loan does not close. So we've got our contract then. Now the next thing to do, assuming that you have a financing situation with a lender, you would take that to the lender. Now, if it's a cash closing or if it's an owner finance, you don't need to go through this. But Neal, can you tell us some of the bank requirements or the lender's requirements prior to being approved for a loan?
Well, usually the lender requires all your financial information about your employment, your credit history, and all that. They look that over to make sure you qualify for a certain amount of a loan, because unless you have a certain income, you would not qualify. And of course, each institution might have slight variation on what amounts qualify for which loans. And also the major thing that the bank would require is an appraisal of your property, as you might guess, because if it doesn't appraise for enough for you to buy, qualify for a certain amount of loan to purchase a property, then of course you've got a problem right off the bat. But basically, it's your combination of your wage history and a credit report, the and the appraisal of the property determines whether you obtain a loan. And of course, banks have certain programs at certain interest rates. And it's always good to shop around, I guess, because these interest rates, although they've been pretty steady recently, they tend to fluctuate. So,
Right. One other thing, you generally will have two types of loans depending upon the lender, and they would be an in-house loan or a secondary market loan. Now, can you explain what the difference between an in-house loan and a secondary market loan would be?
well, in-house loan is basically what it says it is. It's in-house. In other words, it pretty much stays with the bank that you get the loan with. A secondary market loan is a type of loan that usually, at least the banks around here, they sell on what they call the secondary loan market, which is basically the big banks throughout the country buy pool of loans and to get better financing and to pool it so they can make more money, basically, I guess. But it doesn't really affect the buyer, because whatever your loan rate is with your bank, whether it's a secondary market or in-house, your contract doesn't change. It's just who your payments may be made to, are going to be the change. Usually the secondary market are fixed rate loans, at least they have been recently, and in-houses can be fixed or it can be adjustable depending on what, the situation is.
Okay. Now, let's say that your lender contacts you, and also some people are pre-approved for loans too. They know that they're going to buy a house, so they will contact a bank and get pre-approved for a mortgage up to a certain amount, and that will speed and streamline the process. But once you've been approved for closing, there are certain other items that the bank requires. Once your credit's been established and your employment has been verified, they will usually require some tax returns to verify this, and they will require certain other items such as a termite letter, a flood certification, title letters. Can you explain basically what an attorney will do on a title letter?
Well, attorney, you've heard the term searching the, excuse me. Searching the title is basically searching the records at the county clerk's office where the property is located. And what you're searching is for any liens against the property, the current owners, or anyone in the chain, what we call the chain of title, which basically you go back 30 years, search records of ownership for at least 30 years, and you determine what mortgages are against it, whether taxes have been paid, were there any other liens, tax liens, or any judgment liens from, say, any credit card debts or something that might be out there. And you also check the adequacy of the legal description and each one of the documents in the chain to make sure there are no errors there. So basically, an attorney doing the actual title just tries to check everything to make sure that, that a good and clear general warranty title can be delivered to the new purchaser.
Okay, we talked about liens, and basically you can only check the records at the courthouse for those liens, because when there is a lien against real estate, the courthouse and the county clerk's office is the location to file those liens, and the purpose for that is to put a claim upon the real estate. So if the lien is not properly filed at the courthouse, then there will be no way that it can either be enforced or it can be detected by someone checking the title. Now that we've received the bank has received the title letter, and they've determined that there's insurance that's going to be bound, and that the property is free and clear of termites, and it's not in a flood zone so that they would require flood insurance, or if it is in a flood zone, then flood insurance would have to be written. You would be approved for closing. And explain what a closing is. Just the term closing is used universally, I think, with everyone.
Yeah. Well, closing essentially is where you sign all the documents. You bring your money to pay the seller if you're the buyer, or if you're the seller, where you receive your money. And at that, it's more of a, once everything, hopefully there's no problems and it goes smoothly, it's the culminating act in the purchase of the and sale of the property. You sit down, you sign all the documents, which would normally be in a typical document a note, mortgage, a deed. There are various affidavits and what we call a settlement statement, or HUD. You probably heard that term, and all that is it just sets out all the closing costs, tax prorations, any escrows that the bank may require to pay your taxes and insurance, and other documents. Sometimes when you do a secondary market loan especially, there are probably a couple dozen documents altogether, affidavits and compliance or revision agreements and all sorts of things that sound pretty detailed and complicated, but really when it boils right down to it, they're really pretty simple documents for the most part. Basically, you're sitting down and closing the deal is what it amounts to.
Well, basically, as a seller, I think the sellers don't have the documentation that is been required to be signed as would the purchaser. And I know since the Patriot Act has come through, we're also requiring picture IDs of the purchasers. And even though a husband and or a wife will take title in their own name, the spouse is required to sign pursuant to Kentucky law to ensure that all statutory rights are transferred in the documentation. That is something that a lot of people misunderstand, and if they're buying it, they think they are the only one that is required to be there. But if they're married, the spouse will be required to attend. Now, we talked about signing a deed. Can you explain what a deed does?
A deed essentially transfers record title from the seller to the buyer. And the deed, since about 1990, Kentucky changed the requirements of the deeds. Now it used to be just the seller would have to sign the deed. Now a buyer and seller both have to sign the deed, and they both have to certify in the deed itself that the amount being paid for the property is a true and correct consideration, which you didn't used to have to do in Kentucky, but now, for the last about 15 or 16 years, you have to, both buyers and sellers have to certify that. Or if it's in the case it's a gift from like a parent to child, then you have to certify that it is a gift, and then you also have to set out the fair market value. And and the deed also sets forth your legal description, which is either what we call meets and bounds, which gives you your calls of certain feet and distances, or it could be just a lot and block number in a recorded, subdivision, which will state that also. But your deed is basically your transfer of title from the seller to the buyer.
Okay, now we also hear a lot of people talking about the term mortgage, and they'll use those terms interchangeably, not really knowing what they are. Can you explain what a mortgage does?
A mortgage gives your lender, typically a bank, a lien or security for your property. In other words, if you do not make your payments on time and default for more than, usually it's a 30-day period, or it could be 60 depending on the situation, then the bank has the right to call the entire amount due on your note and file a foreclosure action in court to take the property back, basically. And they have to do that, through court. They can't do that, without going to court anymore under Kentucky law. So basically it gives them the right, if you do not make your payments, to take the property away from you.
Okay. As you said, that there are quite a few documents to be signed at the closing, and I think you previously stated too that you would have, depending upon the loan, whether it's owner financing, whether it's in-house loan, or whether it's secondary mortgage, then you would have different types of documents. But for most of the bank loans, the same documents are used. You will have a certain core group of documents consisting of the note, the mortgage, the HUD one, as you stated, the truth in lending, and generally a payment statement. And you'll also have an escrow document. Now, can you explain what an escrow account is with a loan?
Well, basically, if you have an escrow account, either voluntarily or sometimes the banks require it for on certain types of loans, what you're basically do is you're paying your taxes and insurance, your homeowner's insurance, what I'm talking about now, you get generally, every month instead of paying them, once a year when they're due. So what you would do is set up part of your payment every month will go toward a fund, what we call the escrow fund, for payment of these taxes and insurance. And so when you would get your bill, of course, typically in McCracken County here and most counties in Kentucky, your bill comes out for taxes in, usually around October or November. And so you would get your bill when it came to you from the sheriff's office. You would take that to your lender, and then they would pay that out of your escrow account. So it's just basically paying per month rather than paying once a year. And your HUD will state that, how much a month is being set aside. And generally they have what they call an escrow account notice in your loan papers, which gives you a list of what should be in there every month and how it grows, and then when it's paid out, how it is reduced every month. So you'll know pretty much every month how much should be in there.
Well, basically what they're doing is they're ensuring that the taxes are paid and the insurance is paid, because you pay to your lender every month
Right.
an amount equal to,
Right.
basically it's 1/12 of the taxes and 1/12 of the insurance.
Essentially, yeah.
Now we're at this closing. Now, once the documents are signed and the money changes hands, and generally the money is in the form of a cashier's check because it has to be collected funds, once all of this is completed, then what would your duty be as a closing agent or in handling the closing?
Your duty as closing agent, just other than, of course, hopefully you've reviewed all the documents beforehand and they're all correct. That's your primary thing, that everything's taken care of as far as all the documents being correct when you get to closing. And then at closing, you make sure that everything is signed correctly and notarized. Some of the documents will have to be notarized by a notary public. Either the attorney is a notary or someone at the closing who witnesses the signatures would be a notary. Generally, the attorney is a notary, so they usually do the notarizing. And then all the money you've collected, the certified funds to be paid out, and you would pay out all the checks to the seller. If there's a loan to be paid off, to the lender, and then any recording fees that go to the county clerk for recording your deed and mortgage. Basically, you're collecting the money and then paying it out to those parties that receive money, the realtors, courthouse, any other bills that may have to be paid, any taxes that might be due and payable at the time.
So in essence, everything you collect is paid out through this closing.
Right.
And the documents are recorded or taken or collected to be recorded at the courthouse, and your debts against the property are all satisfied, so that your purchaser will then have good title to the property, and your lender will then have the good first mortgage on the property, which they require. Sometimes there are second mortgages also occurring at closing. Can you explain what a second mortgage is?
A second mortgage usually is what we call a home equity loan. So if your first mortgage, if you still have equity, sufficient equity after having a first mortgage, sometimes you can have a line of credit for an additional amount that you can draw on if you need to draw on it, for other purposes other than your purchase, the amount of money you need to purchase the property. Generally, it's a line of credit most of the time when you have a second mortgage also with your first mortgage that would, because the lender can lend up to a certain percentage of what your appraised value of a house is, 80, 90, or sometimes even 100%, depending on the lender. So, if your first mortgage is only, say, 75 or 80% of your value of your appraisal, then they could give you a line of credit for another 10 or 15% that you could use if you so desire to, make improvements in the house itself if you want to, or buy a car, or pay other debts and credit cards, or whatever, you feel like you might want to do with it, or not use it at all, just have it there just in case.
I think the beauty with the second mortgage is, much like the first mortgage, is that the interest is going to be tax
That's
deductible.
true. That's one of the big selling points, that if you do
Right.
use that, it is tax deductible.
Okay, and so once we complete the closing, basically your seller has the cash and your purchasers will have a new residence and an obligation to pay. Well, let's talk a little bit more about our role as attorneys in this process. I think the first thing that we've spoken about was the contract, and I think you want to make sure that your contract for purchase of property is valid and it is followed throughout the transaction. We've talked about checking the title, and we want to make sure the title is clear. But one other thing, Neal, about the title, there are a couple of ways that we can verify that the title is cleared. The first one is with a title letter to the bank telling and setting out what the condition of the title is. But the second is a title insurance commitment. Can you explain what that title insurance commitment is?
Well, the title insurance commitment, as far as the attorney is involved, as far as running the title, you're doing the same thing. Once you've finished the title work and figure out what exceptions or what problems there might be that you want to tell either the bank, or you put on a title commitment to the title insurance company. What you're doing is if you're doing a title letter, the attorney himself is insuring the title to the bank. In other words, he's putting his errors and omissions insurance policy on the line. If you get a title insurance, the attorney himself is being backed up by a title insurance company that would pay if there are any problems that were missed by the attorney, essentially, but which hope we don't have that. But basically, there are two types of title insurance commitments or policies. You get the title commitment, which we would give a commitment to the title insurance company setting out what the condition of the title to this piece of property is. And then generally they would write what we call a lender's policy to the bank, ensuring that the bank will have a good title for the amount of that loan. And also, we haven't talked about, you can also, in addition to a lender's policy, which the bank would normally require, you as an owner can get, for an additional premium to the title company, can get what we call an owner's title policy, which covers the title to the property to you as an owner for the entire time that you own the property. It's a little bit more costly than a lender's policy, but it lasts the whole time that you own the property rather than just the length of time that your mortgage is on the property if you paid it off, before you sell it. So essentially, the title insurance it's another insurance policy. It insures the title, just like your homeowner's insurance insures your physical house there from damage. The title insurance company is insurance for the title to the property itself.
Well, that's good, and I'm certain a lot of folks have heard the term title insurance and insurable title, and that's a good explanation. Now, after we make sure the title is clear, then we also, as an attorney, want to make sure the documents are accurate, they're according to contract, and the proper people sign the documentation. We want to make sure that if a seller is selling, that both, and it's a husband and wife, both have signed the deed and signed other documentation. We also want to make sure that they do follow the contract. In other words, that the exact terms of the contract are met as far as your deed and other title vesting documentation. We also want to ensure that the money, the purchase price, the payoff of loans, payment of delinquent taxes, these are all made and properly dispersed at the closing or post-closing. and that the new documents are recorded to vest the title in your purchaser, to ensure that your lender does have a good first mortgage, and that we also want to follow up and ensure at some point in time after the closing that your old lender, which was paid off at the closing, that they will file whatever documentation is required to release their mortgages, or if they're lien holders, that they, after they're satisfied, they properly release their liens. And once this is all completed, then your purchaser and your lender both know that they have good title, and you supplement this with, as you said earlier, a final title letter setting out these facts, or a final title policy, either a lender's policy or an owner's policy with a lender's policy, so that there would be title insurance on the property. Going back to the title exam, there are a couple of other areas that you want to check for also, and one would be subdivision restrictions. Can you explain a little bit what a subdivision restriction is?
Lots of times, and more as we become an urbanized society, most people live in, private or not really private communities, but in subdivisions that are restricted as to what type of house you can build, how far back it has to be from the street. I mean, we all, and what this does, it creates a certain amount of uniformity in all the homes in a certain subdivision, as to price and basically construction materials. And of course, there are a number of ones here in Paducah, McCracken County, which the more and more of the people are living in subdivisions now. And so you have to be aware, if you just buy a lot and going to build your own home, that your contractor and you are fully aware of what has to be done to meet the requirements of those restrictions, as far as what the materials, like whether it be brick or whether it can be siding. And then, of course, the contractor must be aware of any what we call minimum building line restrictions are, which essentially means your house has to be a certain number of feet from the street, or from the back lot line, or from the side lot line. So, we've had people build, as you might suspect, not paying much attention to these things, and have a house that's built over a building line that can cause all sorts of problems. But more and more, as we, become more of a urban area here in McCracken County, more and more people live in subdivisions, and you're under restrictions to what you can and cannot build, and those are all set out in the restrictions in the subdivision. So you need to be aware of those.
Well, thank you, Neal, and we thank you for joining us today on Paducah 2 and on People's Law School, and we thank you for your viewing. And if you have any questions, you could contact us or any other member of the McCracken County Bar Association. Thank you.